Welcome everyone to today's webinar, the first in our exciting series about the intersection of GenAI, national security, and the law. Today's topic is going to be navigating the legal landscape of GenAI, protecting your business in the age of AI innovation. So unless you've been living on a rock for the last 6 months, you've heard of GenAI. Generative AI, as it's called, is the latest and I think the most powerful iteration of AI. So artificial intelligence obviously has been around for a while. We've been hearing about it in our lives, but I think a lot of us, it's kind of background noise, right? Generative AI has made a big splash because it's the first AI that is really interactive in a way that allows us to create new things, hence the generative portion of this. We can talk a lot about the genesis of GenAI, but really the focus today is this intersection between this new technology, something we care a lot about, national security, and something we do every day, which is the law. And generative AI is going to find its way into every nook and cranny of our professional and frankly, our personal lives as well. So I'm pleased today to be joined by two of my great colleagues, Phyllicia Tanenbaum and Brad McConnell. I'm going to let them introduce themselves before we dive right into this great topic. So Brad, over to you.
I was muted, trying to be good. So good afternoon. I'm Brad McConnell. I am chair of the corporate and transactional practice here at Fluet. I've been in practice for more than 28 years, almost exclusively focusing on corporate and transactional matters. So I got my start in venture capital and startup companies and technology companies back in the 90s. So this issue is sort of near and dear to my heart just because, but it's both about AI, but it's also about contract law, which, I may be unusual, but I find it kind of interesting and exciting. So I'm excited to talk about the topic. Phyllicia?
Great.
I'm Phyllicia Tanenbaum, and I recently joined the corporate M&A team here at Fluet. Prior to Fluet, I focused on bankruptcy, restructuring, and workouts. I later expanded my skill set to include corporate and M&A work for clients in the GovCon space. And I'm fortunate to work now with such a great group of people here at Fluet, where I primarily focus on M&A, venture capital, debt financing, and reorganizations for clients in the GovCon, technology, aerospace, and defense industries.
Great. So Brad and Phyllicia, before we dive into the topics, I'd like to ask you a different question. How have you personally used GenAI, and what do you find most interesting, fascinating, or exciting about it? So, Brad, you start.
That's a great question because, quite frankly, AI and machine learning and all that kind of stuff, I'm sort of aware of over the last 20 plus years. In fact, my uncle was working on pattern recognition AI stuff even back in the 80s, right? So it's something it's one of those things where, it's an interesting science fiction-y kind of idea. And, it's a natural use for computers, but, what's that going to look like? But obviously it's been, in this past year when sort of the sort of experiences that people are having, the awareness of AI with this sort of next generation of generative AI, which is just sort of, it's kind of attracted a lot of attention. It's appealing, it's interesting, it's exciting. And I will tell you, I started playing around with some of the various models to, whether it's creating an outline for, a potential piece I want to write about. Obviously it's not a substitute, but it's a nice way to sort of like, oh, here's some ideas that I can work from. That's one of the ones I've been most interested in, just because it's kind of a way to go from a blank piece of paper to start the process. But I'm excited by the ways that it's being used. I'm excited about the future for it. And I know there's a lot of potential for us just in the practice of law as well, whether it's part of analyzing contracts as part of due diligence. I think there's a lot of future there. Remains to be seen, how that will be implemented. But so it's a combination of personal interest and, the potential for professional interest as well.
Right.
Like
Thanks,
Brad, I've used it recently a few times just to get an idea, what will it do when I get a little bit of information, and then I let it take me from a blank nothing to kind of a template. I just want to see how it handles it, what's out there. And then I do see that, you still need that human checker to make sure that things are getting put in properly, especially when you're using it in a professional setting. And you do need to run those checks, which we'll get into more today. But yeah.
And not just draft a brief based on imaginary cases that don't exist.
Exactly.
Yes, we could talk about that case later today,
I think we will.
Yeah, and we will. Fantastic. Well, let's go dive into the meat of this matter. So, Brad, obviously with all kinds of new technology pushes boundaries, right? It pushes society boundaries, it pushes people to think about existing problems in new ways, and it pushes legal boundaries, right? We have obviously laws and regulations on the books, and when new technology comes out, those laws and regulations may be applied in new ways, or they may be applied in different ways. So one of the issues facing these generative AI companies is legal challenges. So for those who don't know, GenAI refers to a huge category of artificial intelligence, all of which have one thing in common, which is the ability to generate something new from the data it's been trained on. The most popular type is what are called large language models. These type of generative AI take huge corpuses of text. Think the entire internet, all of Wikipedia, or the entire catalog of the Library of Congress, and are trained using something called transformers, so that when you put in a text input, it generates an answer based on what it expects, what it thinks you expect to see next, right? What the next word, what the next syllable, what the next part of language should be to generate an answer that is useful. Now, these large language models, of course, are trained on these corpuses. These corpuses of data have to come from somewhere, and this data has raised a lot of issues already. So, Brad, so what are some of the kinds of legal challenges already facing generative AI companies? And what are the kind of cases we're seeing already?
Yeah, there's two basically big buckets of stuff, right? That's sort of already sort of leading the charge in the stuff that's getting challenged in courts, because, and as you say, that there's existing laws that exist for intellectual property protection, but anytime you have new technology, it may stretch, whether that makes any sense, right? I mean, the internet has massively changed laws and it takes a while to catch up. So, I mean, sort of the vanguard, or there's sort of the data privacy and security cases. And quite frankly, the other one, which gets a lot of attention, is, copyright, intellectual property, like who owns it, what happens when it's being, when these AI models are using this data, it's so, and there's all kinds of issues around that. And I think one of the things that, it's kind of the throughput for this whole discussion is, even if you are not a AI company, being aware of what those issues are may be important, because using these AI products is going to become, can expose you to those concerns. So that's why we're sort of, this is not just something for AI companies. This is going to be something for everybody, just because AI companies are going to be everywhere.
So as I've listened to you say that, Brad, if I was sitting here on the webinar and I'm using generative AI, all of a sudden I might be worried, like, wow, am I at risk using these tools and putting it out into the world? Am I going to be sued by somebody whose data was used to train that model? Is that going to happen to me?
The short answer is, yeah, maybe, possibly, and it's, this is where we sort of, as I say, like, there's an existing framework of laws, right? And for like a long time now, there's a potential for you using someone else's product, and it turns out, or service, and it turns out they're violating someone else's patent, they're violating someone else's copyrights, they're violating some other party's intellectual property. You're potentially going to be sued for that, right? That's, even though you're not the one doing the violation, you're the one using it in a violative way. So some of these issues, if I'm using an AI company, because we don't have the sort of a coherent framework, it's much more of the Wild West in terms of, if I'm using this, even from a reputable company, am I somehow misusing someone's confidential information based on the way it's been, that this AI model has been built? Am I misusing someone's copyrights? Am I going to be sued for licensing just because of the way that I've either using this internally or incorporated into my own products or services, right? So that's where we're trying to sort of argue by analogy and try to be as cautious as we can for what's otherwise an exciting new area that, a lot of people are going to want and need to adopt.
Right. Is that likely to happen, Brad, as an individual user?
As an individual user, probably not, right? But the bigger it's one of these things where the bigger you are as a company, the deeper your pockets, the more likely you get someone's attention, right? Because one of the ways that our economy works is, if people feel like they are being wronged, if there isn't a government way to solve that, then it's a lawsuit, right? For good or for ill. It's So if you are one of the problem, if you are a big name or something like that, or you are, one of a bunch of defendants that can be sued, and they see that you are somehow using this, that just the same way, once again, the same way as if you're misusing, you're violating someone's patents or other intellectual property, that you could very well be subject to this kind of lawsuit, which presumably you don't want to be, right?
So let's talk about the current lawsuits, Brad. What's happening out there, and who are they targeting? Are they targeting the makers of this technology? Are they targeting companies that are using outputs? Are they targeting individuals?
Initially, the lawsuits, for obvious reasons, are targeting the actual AI companies for the most part, right? We're seeing, because that's where it's like they can see who are these companies that are, whether it's creating some kind of images or words or whatever it is, and the owners of the underlying copyrights that feel like they're being infringed. Same with sort of using some of the same analogies to the music industry and art, all these kind of things where who does, is what you're doing violating someone else's intellectual property? So yes, tend to go after the AI companies, and at least initially, right? Because they are the logical first target.
Okay. And is there any particular case that stands out to you in the pantheon of cases, Brad, that's maybe a good representation of this issue?
Well, there's a few of the cases that have gotten, besides the lawyer who wrote a brief based on non-existent cases, right? But there are some of these cases, like Anderson versus the Stability AI, and it's like, I'm a corporate lawyer and I'm now looking at cases, which is always one of these things where it's like slightly dangerous, but we need to know about them because it's what's coming next, right? So and that's one of these companies where they're it has to deal with this issue of scraping, right? Where it's like, how are we training these models? And if it's just based on the internet, what is that? Do you have the rights to use this? How is this? Are you going to start scooping up other people's intellectual property that becomes part of your product, either inadvertently or intentionally? What is what kind of duties do you have, right? So are these, and what areas of intellectual property law are you applying? Are these derivative works? Is it fair use? All these kind of things, right? So, and I don't want to step on some of Phylicia's stuff that she wants to talk about too, but it's, it's one of these things where, there's also Doe v. GitHub, which is another one, which is sort of on the other side, which is the, if I'm using these tools, in that case where they're using their code, using the AI tools on their own, proprietary code, is the AI then going to use the information based on how it's learning, which is looking at these large language models, right? Is it now using that as part of if it's generating code for some other party? So do they, what does that look like? And obviously, the more that there's uncertainty, the more risk, and the less, the harder it is to adopt these kind of technologies. So those are two of the ones that certainly have stood out as some of like the new kind of lawsuits that we're seeing.
Got it. So these lawsuits are targeted at the makers of AI. What else do you think is likely? If you had a crystal ball and predict what the future lawsuits will be, who will they target, and what will they bring as claims?
Right. Well, there's going to be a range of things, right? And it's, once again, it's kind of, and we can talk more about, how AI is being used, whether it's being used in a chat bot, or whether it's being used to generate content or manuals, or it's being trying to answer questions or make analysis of large amounts of corporate data. Depending on the various uses, there's all kinds of areas where people can wind up in trouble. More of the intellectual property violations, right? Whether it's not just, code or images and stuff like that, any kind of stuff. That's obviously going to be one of the big areas. And improper use of or disclosure of personal information, that kind of stuff. There's going to be cases, just like with all other sort of cybersecurity issues, where is personal information, which we have this very high degree of concern about, is that now somehow being incorporated, misused by these companies, or is, or quite frankly, is the user of this exposing this information in a way that they're the ones actually effectively violating it, because they are not using the appropriate level of care in managing this personal information, credit card information of customers, personally identifiable information of customers. Is that, quite frankly, there's going to be issues, I think, over trade secrets, right? Trade secret, there's a whole area of law around trade secrets where what you do to maintain the secrecy is important, and how is the actual even use of some of these AI models somehow going to undermine the trade secret protection, right? I think we're definitely going to see stuff about that. We're probably going to see stuff about, defamation, as people are an AI says something nasty about somebody that it's just, that's odd. It's like, well, is that defamation? It's not a person. That's not my area of the law. But you have these things where, to the extent that computers are now creating text or interacting with customers, even if you disclose it, what does that look like, right? This is some of the sort of the brave new world. And and even the analysis side of things, if we're doing analysis of data for whatever reason, maybe it's hiring, trying to go through, I've got, or admissions to college. If someone's looking at hundreds of thousands of applications, or hundreds of applications for a job, is the language model, does it contain, either intentionally or more likely unintentionally, biases based on what historically, if it's trying to find, even if it's just a computer trying to say, well, these correlations seem to be there, they may not be intentional, but you may be sort of perpetuating some of that kind of stuff. So is that, I'm almost certain something like that's probably going to happen in the future too. So there's a whole bunch, kind of like wherever stuff is happening, there will be lawsuits, and we'll try to figure it out.
Great. So Phyllicia, how are these generative AI companies defending against these lawsuits, right? So one facts about our society is we have a very litigious society. It wouldn't be too far to say anybody can bring a lawsuit against anyone for just about any reason, but we're not far off. So, Phyllicia.
Sorry, my light just cut out. I didn't want to go dark on everyone.
That's okay.
Yes, a variety of defenses.
You're too still there, right?
Yes.
Yeah. A variety of defenses have already started to be effectively asserted by these defendants, namely lack of standing, reliance on the fair use doctrine, and the legality of data scraping. So with respect to standing, if the plaintiffs cannot demonstrate that their specific information or work product was improperly used by the model in question, then their claims fail for failure to establish that required injury in fact. The fair use doctrine, that serves as a defense when copyrighted material is used in a transformative way. The doctrine seems particularly appropriate for the AI training process, which, as you explained, France, does not involve the traditionally impermissible copying and commercial reproduction of copyrighted work. Instead, it's analyzing copyrighted material to detect patterns in an effort to then develop a new function or application, specifically a large language model or other GenAI product. To date, no US court has explained the appropriate application of the fair use doctrine in the context of GenAI models or AI generated materials. GenAI developers, they're not the first group of companies to scrape the internet for commercially useful information. It's common practice among data science, technology companies. It is important to note that accessing publicly available data does not constitute access without authorization under the Computer Fraud and Abuse Act unless the data has been marked private.
Got it. So what do these plaintiffs actually want? You sue for a whole host of reasons, right? So what do you think these plaintiffs want? So
at the forefront, they want permanent injunctive relief. So they want to stop the infringement of their copyrights and trademarks. So that's basically in all of these complaints, you're going to find that. They want to destroy all versions trained using content without permission. And again, this is what they're asking for. So this is the extreme sense of what the plaintiffs want. compensation. They want profits, gains, advantages, the value of the business opportunities received, damages suffered. So in some of the cases Brad had mentioned, Getty Images versus Stability AI. I just want to go into a little bit of the numbers, an idea of the magnitude of these damages and what they're alleging. So there's a $150,000 maximum for each infringed work. In that Getty Images versus Stability AI case, there were more than 12 million photographs involved. So that in and of itself, you're looking at $1.8 billion on copyright infringement alone. They also want statutory damages for willful acts of trademark infringement and unfair competition. Brad had mentioned the Doe versus GitHub case. And in that case, we also see additional requests for breach of licenses and punitive damages. In that case, the plaintiffs are estimating statutory damages will exceed $9 billion. Now that figure represents minimum statutory damages, which are $2,500 each. And they're saying that those were incurred 3 times for each of the reported 1.2 million users. So each time the AI provider provides an allegedly unlawful output, it violates, they're saying, Section 1202 of the Digital Millennium Copyright Act 3 times by distributing licensed materials without attribution, copyright notice, and license terms. You can see how
that sounds
numbers can add up.
So yeah, even without my lawyer hat, that sounds scary.
Right.
Now, plaintiffs often ask for scary amounts of compensation. So what do you think is going to actually happen? How do you think this is going to be resolved?
Well, I think that there are increasing calls for royalty payments to copyright owners for use of material and training the models. 2 views are emerging. One in support of a single upfront fee to use the materials to train the system. The other view suggests that each GenAI work should pay royalties back to the rights holders whose works inspired the output. We can also expect to see changes in policies and new legislation. So the regulation of AI currently in the US, it's still in its early stages. There's no comprehensive federal legislation dedicated solely to AI regulation right now. There are existing laws and regulations that touch upon certain aspects of AI, such as privacy, security, and anti-discrimination. We can see the 2023 legislative session has seen a surge in state AI laws proposed across the US. And also right now, the European Union, they recently took the first step toward passing the Artificial Intelligence Act, which essentially it will create a risk-based regulatory framework whereby regulation would increase in proportion with the potential threat to privacy and safety that an AI system poses.
Got it. Okay.
And one of the problems, one of the problems
Yeah.
we're going to have is, and Phyllicia brings up this great point about both international and state laws. It's like, it's not like you're just going to use the internet in Virginia, like for instance, where I'm sitting right now. I mean, what is that sort of uneven attempts at applying to, various state or international laws to, copyright infringement? I mean, what's that going to look like, right? So that's
correct. And with the European Union, don't think that because you're not in Europe that
exactly.
you're going to also be held to the Artificial Intelligence Act. If you're targeting those users and they can use it, which internet is worldwide, then we're also, you have to pay attention to what other countries are also doing with these kinds of
and whatever solutions, that some of the stuff that Phyllicia was talking about, whatever solutions that the industry comes up with, if it's microtransactional licensing sort of fees on things that are that somehow can be related back, that would obviously lead to a certain set of regulations to try to deal with that and enforce that. But if it's upfront licensing, that'll be different as well. And some of it's going to be like, well, what actually works, right? Because we've tried a bunch of things in a lot of different intellectual property rights areas. But one of the things that makes this so interesting and sort of cool, neat, quite frankly, is also one of the dangerous parts is like, you can have, I want to write something in the style of, some writer, or, I literally last night, my kids are both Swifties, and there was a song, there was like an AI generated song, a breakup song about Taylor Swift breaking up with Travis Kelce, like in the style of Taylor Swift. Obviously this hasn't happened yet, but it was, I mean, it was a terrible song, but it was funny. And it was definitely like the voice sounded kind of like her. And it was sort of like the kind of song that she would write. So, I mean, and because it's, I mean, there's fair use, and then there's like, this is really starting to get kind of close. So what's that going to look like? And it's because you can, as Francis, you well know, that you can do stuff in the style of. Now, is that changing things, in terms of, what licensing might look like and all those kinds of things, right? So I think there are novel issues here that are obviously different from, from other intellectual property, issues that we're just going to have to see what's going to happen.
Yeah. So we've been talking about these lawsuits because they give us a glimpse, right, of where the current legal landscape is and where the early litigation is. And that often is a leading indicator of what could possibly follow. And we've talked about some of the risks these companies have and some of the likely defenses and how these cases might resolve themselves. And as Phyllicia kind of hinted at, it's probably going to come down to the money, right? The sides want a piece of the action, a piece of the money, and how's that going to be resolved? And we've seen this before, right? When streaming services started, when music started being streamed, very similar types of question arose. So if I'm on this webinar, I'm here because I'm interested in using GenAI. Unlikely, but there may be somebody developing their own GenAI on the call. That's one category. There may be people with businesses that intend to be in the GenAI space that are building on what we call foundation AIs to build a better AI. There are probably highly likely business owners who are thinking about incorporating GenAI and allowing their employees to use it. And then certainly all of us are individually using it in some way. So, Brad, what are some of the risks that a company, right, might face in using GenAI at this point?
Yeah, no, and that's kind of the $1 million question, right? And that's where, we like to think we add value, that the lawyers do, are a necessary evil, perhaps, if we add value, because you do want to protect yourself. There's a lot of pressure, both just because it's exciting new technology. Sometimes it's from, the higher ups of companies are like, I must have AI in what we're doing, or our HR needs to incorporate AI tools, or we can see savings from doing customer interaction using AI, and sometimes it's the customers that are demanding it. Sometimes for our government contractors, there's already been a push towards machine learning and AI. There's gonna, just with all the headlines, people are going to be saying, I must have AI. My 84-year-old father-in-law, who's a retired surgeon, is like, he watches the news, and he called his broker and said, because he calls his broker because he's 84, and says, like, you got to get me in some of these AI companies, right? So he's like, he doesn't know anything about AI. He doesn't exactly know what it is, but it's there. So there's going to be all this push, and there's, my feed, on LinkedIn or X, formerly known as Twitter, or whatever, it's full of all these different companies saying, hey, use AI for practice management, or for your due diligence, or for your whatever that is, right? So there's a barrage of this kind of stuff, right? So people are going to be using it. It's going to be hard to not use some of this stuff. So then the issue is, so which is that, so how do you protect yourself? And the bottom line is, it comes down to contracts, right? It's like, well, that's the most important as far as I'm concerned. But there's the issues we're going to have, are is the information that's being generated from this AI, is it accurate? Are you now, are you making decisions or doing stuff on behalf of your customers based on inaccurate stuff? Going back to that, that lawyer who had a really great brief, except that the cases were made up, right? If these AI systems are, even if it's just a one-off kind of thing where they kind of made something up that's not true, to the extent you're relying on that or incorporating that into something you're doing, that accuracy could be a huge problem, right? It could or they could just be missing out on stuff because it wasn't part of the model they were training on. So, you're coming to conclusions that are missing out on key things that you should have known. We talked a little about the biases before. Are you opening yourself up to biases, up to lawsuits based on that kind of stuff, right? If you're using it for hiring purposes or promotional, especially in HR areas, that's going to be an issue. And we have a whole seminar that's going to be on that in a couple more weeks. And then there's all these issues that are going to be around the use of your personal information, whether it's your clients, your employees, whatever that might be. How is that being used? Is it being, is it being disclosed inadvertently? Do you have, or do you even have the rights to be using some of this, especially if you're using third-party data? This is something we see in other things outside the AI world is, do I even have the right to let this service provider act on this data that I have licensed from somebody else? And the question is, I don't know. It depends on what your contracts look like. So, and then there's the last one we talked about is like the licensing issue, right? Just like, are you appropriately, is either you or the company you're working with, do they have the licenses to use this information? And if not, that tends to flow through to you if you're using it, right? Are you now going to be sued for misusing or using without authority, out of license, someone else's intellectual property? So there's a bunch of stuff that will flow through to just the users.
Yeah. So let's put a very tangible point on this. So I'm a user of a GenAI tool, whatever, pick your poison. I create a piece of artwork in the style of someone, right? Mm-hmm. I post it, I commercialize it. Am I at risk of being sued by that person for a copyright violation?
I'm not a copyright lawyer, but I'm going to say, yeah. Yes, you're at risk. That's the issue, right? And the issue is it worth that risk, quite frankly, right? Because it's one thing for the AI company in this Wild West situation to take on certain risks. The risk is always part of doing business, right? So you look at that risk reward profile, you build in insurance and whatever you can to, minimize what those risks are, or try to quantify them and, control them as much as possible. But now if you're just a user of this and you're also exposed to some of the same risks, you need to be, figuring out if that risk is worth it to you, right? Is that so fundamental that risk is worth it? Or, do you need to minimize that risk as well, whether, in one way or another, right? So that's the issue that's why I feel like there's a even bigger risk for the users that may be getting exposed to some of these same issues, just because I think, well, I'm just using this like great new technology from this great new company that I'm hearing all kinds of things about.
Yeah. Now, so Brad, that involved a case where I was clearly imitating someone's style and I'm making money off of it.
Yeah.
Let's change the hypothetical slightly. I just create a great piece of GenAI art. I don't do it in the style of, I just ask it to create something. It's a beautiful piece of art. I don't make money off of it either. I just put it out in the world, right, to share. Could somebody sue me saying, no, my intellectual property was used in training the model that produced that art and this person is benefiting from it?
You can be sued for anything, quite frankly, right? That's not could you be? Sure. Would you be? I think that's less likely, right? I think you're more likely if it's something you're doing in commerce, if you're something you're profiting from directly, and you are basically using someone else's intellectual property as either part of what you're selling or reselling it, if it's just for your own amusement and interest and stuff like that, I think the risks are much lower, right? To the extent it becomes part of your logo or something like that, now all of a sudden it's like, well, wait, I'm using something that's clearly, this seems like it's a ripoff of Nike's logo or something, and once again, we're getting into like nuance of copyright, which is not the subject of this, but it's like, but that's where you have to start being careful that once again, that, what risks are you assuming by using these things? And now how core is that to your commercial benefit, right? How core is that to your compensation? Because if there's, if you're making millions of dollars off something and, part of what it is, potentially violate someone else's intellectual property because of this, AI that's incorporated into it or AI tools that you're using, now there's real money. There's real money and damages, and it's a lot more interesting for a potential plaintiff to look, not for a, well, you made a picture that looked like my stuff, so you owe me 3 cents of royalties or something like that, but here you're actually using my, you should have got a license for this. So now you're getting into all kinds of issues, right? So the more it's tied to commerce, the more it's tied to actually making money, and quite frankly, the more likely you are to be exposed to those risks.
Got it. So grandma creating something to share with grandkids, probably not a lot of risk.
Oh no, so I'm going to sue the crap out of grandma. So it's like,
Got it. Okay, this is a good segue. So how can companies protect themselves, Brad? What we've talked about a lot of gloom and doom. We've talked about all these lawsuits. What can the people in this webinar actually do to protect themselves, mitigate against these risks?
Well, and to some extent, it's the same thing you can do for, quite frankly, all of your relationships with vendors and customers, right? It comes down to whether it's a contract or a terms of service on a website or whatever that might be. And this is one of these things where a lot of people are like, oh, I don't want to, whatever, I'll just sign the thing that's put in front of me, right? So the contracts, and I think that's probably the second thing on this list. I mean, the first thing on this list, quite frankly, is doing your own due diligence, right? Making sure that you are working with reputable companies that are presumably taking appropriate considerations, that are doing their own legal work to make sure, or at least to minimize the risks that they're violating other people's intellectual property or otherwise, or have problems with that they can be easily hacked, and or they're very basically they're training on models that are too small, so that it's like basically you're just getting somebody else's intellectual property or their data regurgitated for you, right? So doing that diligence to make sure you're working with a good company, not just some fly-by-night operator, is certainly the first and best thing. You need to get the lawyers involved in that, quite frankly, right? So, but once you start, that next step is often, so what can you do? So if you decided, well, this seems less risky, so what can you do? And a lot of that comes down to trying to allocate those risks, between you as either the consumer or the provider and the other party, right? And it's like figuring out, who is bearing the risk, who should be insuring against these problems, who should be indemnifying the other party if there is a problem, right? Who is the appropriate party to deal with it, rather than just relying on a lawsuit, right? So it's like, well, we'll figure this out. If someone sues us, then we'll just figure that out in court, right? But looking at this, and this is one of the principles I use with all of my clients whenever I'm dealing with contracts, is it's much easier to agree to what's fair up front, right? And you can decide, yeah, that's fair, both sides, or there's no, there's the money on the table is what you're going to pay, in fees or receive in revenues. But in terms of, what's fair in terms of if things go really badly, whose responsibility is that? Who has to pay for it? Who has who has to defend against those lawsuits, right? So building that into a contract is an important part of what this is. And if it's just, the terms of service of some SaaS that you're using, the software as a service that, maybe there's like, I'm not willing to take those risks, or maybe I need to have a separate side agreement with this, because it's, especially once again, we're getting back to if it's just you using some fun little program to draw pictures, like whatever, but if you're incorporating that into your services, all of a sudden, you really do want to think about it, and it does matter. And there are things that should be your responsibility and things that quite frankly shouldn't be your responsibility.
Got it. Okay, so super high level. You can try to avoid the risk in some way. If you can't, you can try to prevent the risk in terms of service agreements, corporate policies. You can also choose to try to allocate or share the risk in different ways. Phyllicia, how would you add to that list?
Right. So touching on what Brad was saying about the kinds of contracts that you would create, the terms of service, corporate policies, you need to ultimately mitigate the impact of what is going to potentially happen. And so you can include, I'm just going to highlight a few of the provisions that you should be putting in those contracts to do that, to mitigate the impact. Brad mentioned determining the rights among the parties, who owns, who has what rights to use the prompts and the outputs. That should be touched on in the terms of service. Confidentiality requirements. You have to assess whether the prompts and outputs are subject to confidentiality obligations, what those are. Brad mentioned the risk allocation. So certain provisions You want to include representations, warranties, indemnities, limitation of liability provisions that would disclaim, transfer, cap the risk. Providers can push as much risk as they can to the customer and limit their own risk as much as possible. Indemnification. You don't want to over indemnify for someone else's disclosure. Many providers' terms of use do not indemnify end users for any claims, but some providers, especially when you're looking at the enterprise or business accounts, so those are the paid for accounts, they tend to indemnify for claims arising from infringement of third-party intellectual property, typically though excluding the prompt submitted by the end user. We talked about liability limitations. Providers can include very strong waiver of consequential damages language and liability cap provisions to restrict the customer's ability to recover any meaningful amounts from the provider in the event of a breach of contract claim. Disclaimers, you want to cover performance, accuracy, infringement, and compliance with laws as well. And finally, use restrictions. You want to make sure that you include, if you want to have a prohibition against developing machine learning models or related technology, you should reference a prohibited use policy if there is one, explain any safety features that exist to block harmful content, and you should also provide warnings about the user inputting sensitive or confidential information. Don't put your codes and trade secrets in when you're putting in your codes. Brad, I think you also wanted to mention a few other items related to the idea of mitigation.
Yeah, and it's one of the important things just about mitigation, and I want to touch on the thing you just said, though, right there, is these are the kind of issues that we raise, that often our clients, their eyes kind of start glazing over on the contract, right? Because they're focused on, what are the payment terms? What are the deliverables? What are the services? What are the termination rights, right? This is sort of whatever, don't care about. But the truth is, on a lot of this stuff, you need to care about it more, because there isn't just going to be a sort of standard kind of thing that we all agree is what you should do, right? So, and one of the things that Phyllicia was touching on was, if you're, for instance, a company that's using AI and then dealing with your own customers, you may or may not be able to negotiate very much the terms of use of the AI with that AI provider, but then you need to make sure that you are at least trying to do things like disclaim those, the liability for the third party, with your user. Because how's that fair? So you're basically acting as an insurance policy for this company, things like that, where people think, oh, whatever, it's, I stand behind my services, but you don't want to have unlimited liabilities for the acts of other people that really aren't that you have no control over, right? So to the extent that you can, at the very least, you want to understand what you're agreeing to and what you're promising and what that could look like and what the worst case scenario. And I know a lot of clients are like, oh my goodness, you guys are all doom and gloom. And it's like, we're not trying to be doom and gloom, but we are trying to say, in the worst case scenario, this is what, these things could happen. And, how do we know which ones are we really concerned about? Is this a big concern, but small damages? Or is this really unlikely, but if it did, it'd be catastrophic, right? So how do we want to try to deal with those situations to at least minimize your exposure, right? So those are but then some of the other issues that raise and sort of that come from this are, maybe you do have a bunch of exposure that you can't mitigate against, right? So then, can you insure against it, right? Can you add, there's all kinds of new, cyber policies have really, exploded over, as more and more companies are getting hacked and losing their data and have exposure for stuff, or being locked out of their accounts. We will almost certainly see new kinds of insurance policies that will deal with some of this kind of stuff. But can it just be part of your, general, whether it's your CGL or other kind of insurance policies? Can you try to, once again, you may have to pay some money, but can quantify the risk, right? So that if catastrophic things happen, it's not a disaster. Another one of the things that, is how, maybe it's risky, if you do certain things, so maybe we're not going to do certain things, right? So that GitHub case where, if they're using their code, on AI to do some kind of analysis, it may be that's let's not do that. Let's develop policies for our company that says we are not going to use AI in this kind of thing. We are not going to give access to certain parts of our data. We are not going to do certain things with this because it is too risky, or it is, or it's not what we, quite frankly, what we want to do, right? So developing policies, and just the same way you develop other, employee related policies, but how you actually want to use these, these great tools, but only use but not just sort of like, hey, the random people, in the company start saying, well, this would be really helpful for my productivity to start, using these AI tools as part of our budgeting. And it's like, well, wait, we didn't even know that, right? So having policies about how those get incorporated, how those get used, becomes an important part.
Right. Let's open it up now to audience questions. Hopefully folks have been following along and it's spurred them to ask something. You can use the Q&A feature at the bottom and put something into the chat. And while we're waiting on that, perhaps we can follow up on your mention earlier, Brad, about the lawyer using GenAI. I don't know, or Phyllicia, maybe you can opine on that as well.
Phyllicia, you want to go first on that? Or?
Sure. Well, I had mentioned earlier, I myself and just trying to get familiar with, how these systems work. And, there's been a few instances where I just want to see what gets generated. And knowing my personality anyway, I'm doing the human checks of making sure this is compliant with what it should be. So, I do see while it has the potential to do these really helpful things for you and it's just tremendous benefit, I was able to see firsthand that there are those instances where you need to make sure that correct information was put in the first place. Obviously it was not good to submit a brief with made up cases in it. I mean, I know that's not something I would ever do, but a lot of people, in the interest of saving time, you have to make sure that you're harnessing this power in the right direction, using it properly. And that's what we're here for, to help you do that, so you can still benefit from this, great technology, but in a way that you can protect yourself from when things do tend to go awry, which in any, and using anything that can happen. So it's really about, best protecting yourself and how we can, how professionals can help you do that.
And understanding what the limits are of the technology, because it can be a great tool, but it can be, I mean, if you want to use it to write a brief, then that's great, is maybe it gives you the right kind of tone or the right kind of, some kind of structure, but that's like it's always going to be kind of a first draft, certainly at this kind of point, right? Because, these large language models are limited by the data that they have, and we don't even fully understand necessarily when it's making stuff up, right? And you can, that it's, one of the issues was, I mean, I've seen a lot of stuff about, professors using this to test, to see if they think that, the papers being submitted are plagiarized. And then, and they're coming back saying it is plagiarized. And the AI model is very certain that it's being plagiarized, even sometimes when it's not, right? So it's like, but they're very sure about it. So, it's like, so understanding what the limits are and where it can be wrong, and these things will get better over time, but just so you can't just sort of use this like, oh, this will be great, right? So it's like, but it could be super helpful, right? If you're using it as a tool, I think it's a great tool, but there's still limitations, and you need to really understand what those limitations are before you rely on it in sort of the wrong way.
Yeah, one of the things I often say is if you can't come up with a 100% solution without generative AI, you're not going to be able to come up with a 100% solution with GenAI. So the benefit of this technology is, before we had generative AI, if you wanted to go from 0 to 100, someone had to do all the work. You had to do all the work, your team or someone who worked for you or a consultant. The benefit of generative AI is now, for a little bit of upfront work, 10, 15%, what we call a prompt, you can get a solution, but it's not a 100% solution. It's a 70, 80% solution. The better your prompt, the closer that solution is to 100%. And if all you need is a 70, 80% solution, then you can use what comes out of GenAI right away, right? If you're ideating, right? Give me 20 slogans, you don't care, right? You're just going to get the slogans and use it. But if you're looking for a 100% solution, hey, Elbel, give me a second.
Just get my light back on there too.
That is one of my coworkers. if you want a 100% solution, you got to do the work of the last 10 to 15% and get it to 100%. And so everything that Brad and Phyllicia said is spot on. So let me finish up with one last final question for the two of you. Given everything we've talked about, is this technology worth all the risks and dangers involved? So Phyllicia, why don't you go first?
Sure. I honestly feel like it absolutely is. You know, I am a proponent of the AI technology. I just feel like, as with anything, you have to use it responsibly. You know, learn, understand, know your risks, know how to protect yourself, know who to go to help you do that. You know, as long as it's being appropriately managed, you have a professional do the targeted due diligence, put the contractual protections in, have the software safeguards, and, you know, internally within the companies, have these well-considered internal governance controls. You know, you also have to be governing your employees, making sure that they're not putting in protected trade secrets and things like that. But I absolutely think that it is worth the risk. Just make sure that you're, you know, aware of what those are and protecting yourself in an appropriate way.
Great. Brad?
Yeah, and I think, I mean, the short answer is absolutely yes, it is worth it. And I think I've already starting to see some people, like, you know, sort of analogize, like this is the next big wave, like crypto was in the past. But it's like, I think there, and without getting too much into the, you know, crypto situation or the blockchain, I mean, this is different, right? This isn't like something new sort of for its own sake. This is, you know, this is a tool, a productivity tool that can be customized and used in so many ways that it kind of is sort of going to fundamentally change how a lot of things work, some a little bit, some a lot, right? You know, the ability to do things, the kind of things that computers are supposed to do, right? Which is do massive amounts of calculations in a very short period of time, right? And to be able to analyze massive amounts of data, and not just like running some kind of database query, but actually having it learn and use that, and that grows and gets better over time, right? So that it's very powerful. It's going to be, and it's worth the risks, and it's worth the problems that are going to happen, and trying to figure out, you know, how we deal with intellectual property and stuff like that. But it is one of those things that it's not some cool new technology in search of a solution. It's a solution in search of maybe millions of sub-solutions, but it's there, and it's going to be used. And it's a matter of how are we going to use it responsibly, and how are we going to, you know, use it, you know, in a way that you're not betting your company, for instance, on, you know, some productivity tool that maybe it's going to help you 10%, but, you know, you don't want to bet the company on that, right? But you do want to be able to use these kinds of tools. So,
Brad and Phyllicia, thank you so much for sharing your experience and expertise and thoughts. This is obviously an emerging technology, and an even more emerging area of law. And so we appreciate you staying on the edge of that tidal wave, and being here to share your information, and being here for our clients as well. And thank you to the audience for joining us today. Hopefully you found some nuggets, several, we hope, of wisdom and interest here. You can always follow up with Brad, with Phyllicia, with myself, or our firm if you've got follow-up questions. I believe we're going to put our contact information up here shortly. And I'm going to turn it back over to Erica, who's going to talk about what's coming up in our webinar series.